What is the definition of heir at law in a small estate case? Have you ever wondered who gets what when someone passes away without a will? This is where the term heir at law comes into play, especially in small estate cases. An heir at law is a person recognized by state law as entitled to inherit property from someone who has died without a valid will. This situation is known as dying intestate. When someone dies intestate, the probate court steps in to determine who the heirs at law are and how the estate will be divided. In small estate cases, the definition of heir at law stays the same. However, the probate process can be a bit simpler. Small estate procedures are designed to make transferring property easier and quicker when the estate's value is below a certain threshold set by state law. Even though the heir at law is determined through the same legal hierarchy as in regular probate cases, the paperwork and court involvement may be less extensive. Typically, the order of inheritance starts with the surviving spouse. If there is no spouse, the next in line are the children, followed by parents, siblings, and more distant relatives if closer ones are not available. It is important to note that stepchildren and foster children are usually not considered heirs at law unless they have been legally adopted. Depending on state law, common law spouses and domestic partners may or may not be recognized as heirs at law. It is essential to distinguish between heirs at law and beneficiaries. Beneficiaries are individuals named in a will or trust to receive property. In contrast, heirs at law are determined by law when no will or trust exists. For professionals in elder law and estate planning, knowing who qualifies as an heir at law is vital. This knowledge helps guide clients through the probate process, especially in small estate cases. Proper identification of heirs at law can prevent unnecessary delays and complications during a difficult time for families. In small estate procedures, identifying the correct heir at law ensures that property distribution follows the law and is as efficient as possible. This is particularly important for older adults who may have limited assets and want to ensure a smooth transfer to their loved ones. The heir at law in a small estate case is the individual legally entitled to inherit property when someone dies without a will, as determined by state law. The process for identifying and distributing property may be streamlined under small estate procedures. Understanding this concept is central to estate law and elder law practice, especially for clients who have not created a will or trust.